Happy Friday and welcome to Fact Fridays for today, January 30th, 2026. So let's start with understanding what the Camp Branch Acre lawsuit was about and what the non-suit is. This lawsuit was about protecting the legal structure of the Camp Branch Acres Property Owners Association and stopping actions that were taken without property owner permission. It was not about money damages or personal grudges or attempting to close the POA. In fact, the lawsuit could have been avoided or terminated very early. We gave Kelly and Kelly the option to settle by just admitting that they didn't have authority to create a new corporation in our name, to pay the court filing fee, which at that time was a little over $600, so $300 each, and a promise to never do it again. That would be simple and cheap, but nope, they didn't want to admit that they were wrong. They'd rather put the association in jeopardy than admit that. So what actually happened that led to this lawsuit being filed was in May of 2024, two former board members created a brand new and distinct legal entity with the Secretary of State, a new nonprofit corporation using our POA's name. But it was not our POA, and it was a separate and distinct corporation. It was not an incorporation of our association, as they have tried to argue. We know that that's true because there is a process to take a entity and then change it into a corporation, and that was not followed. Instead, what happened was a brand new formation document was filed, which created a new corporation. And the problem here is none of our properties are attached to that corporation. So if we had just continued operating as the corporation that they formed, it would have just been a matter of time. Somebody moves in, doesn't want to be part of the POA, would take a look at it and say, hey, we're not this, we're not legal. And the POA, if it hadn't been operating legally for 3 years or so, could have just been voided and said, nope, it doesn't exist. That's what we were fighting against. It was an existential threat to our POA. And I'm very concerned about making sure that the POA remains and exists because I live at the end of the road. If the POA doesn't take care of this road, the chances of me being able to get in and out of my property easily and safely is pretty much slim to none. What our lawsuit actually asked for was for the court to clarify which POA is real and legal, whether the secret incorporation was valid, and whether those actions violated governing documents. These are all actions that a court can take, especially a district court. The Texas Business Organizations Code clearly states that the district courts have jurisdiction on these matters. So let's take a quick look at the timeline here. In 1967, Camp Branch Acres was established. Not really as an unincorporated nonprofit then. It was established as an association and the subdivision was established. Now, originally the board was composed of basically just the developer, which is common in division developments, in subdivision developments. By the 1970s, we had a five property owner member board, and that's when we would qualify as the unincorporated nonprofit association. When the developer was in charge of the association, it was not a nonprofit, but this is just a process that happens all the time with subdivisions. So from 1967 until 2024, it operated legally with directors, collected dues, maintained the roads, was never incorporated. A couple times, I think they were able to find 4 or 5 documents in the last 50 plus years. Somebody used the word corporation. That didn't make it a corporation, and that's what the Business Organizations Code is about in Texas, is it defines what makes a corporation, what the proper actions are for formation, and the actions that the corporations take, etc., etc., etc. You can't become a corporation by just calling yourself one. There is a legal process to go through, and that was never done. So we were not a corporation. In May of 2024, the two Kellys filed for the brand new formation of a corporation in our long-standing association's name and started really mixing things up, bank accounts, EINs, ZEFI, fundraising, telling disaster resources that we were not nonprofit, which basically disqualified us for any disaster relief from the rains in 2024, while at the same time raising funds in the name of charity, which is a whole other class of nonprofit. It's a nonprofit that is tax exempt, that raises money for other people's benefit, not for their own. So we were never a charity. So in May of 2024, the story is that they had to incorporate to protect property owners, which is false. We were legal before, we've been legal after. Them filing a corporation didn't do anything except mix up all of our books and our legal documents that now have to be untangled, which costs money and lawyer time. In May of 2025, after months and months and months and lots of discussions to try to get Kelly and Kelly to fix the mess that they had created, Mike and I did sue them on an individual basis. We did not sue the association. We sued Kelly and Kelly for their individual actions. These were not board actions. These were not association actions. These were individual actions, and took them to court. That same month, the property owners got together and did vote on a very manipulated ballot that had a lot of misinformation, and the ballot insert was legally voidable. But they did vote, even with the heavy persuasion, or the trying to persuade by the ballot insert. Even with everything that Kelly and Kelly had sent out to try to sway the vote, the property owners voted by a wide margin against incorporating the POA. Now, it's been said that, I don't want the POA because of my business, this, that, or whatever, or I don't want the POA incorporated. I don't care if the POA is incorporated or not. If I had to vote, I would say no, because incorporation adds a lot of legal entanglements that really isn't necessary for a small POA of like 80 property owners. But if the property owners voted for it and it was authorized, then I wouldn't be fighting it. My problem was that none of this was done legally, and it was going to leave our POA open for legal challenges for decades to come. So the current unincorporated nonprofit association structure, which we were operating under before Kelly and Kelly did their corporation, and we have been operating ever since, is legal under Texas law and is very common for property owner associations, the smaller ones. It is created and governed by the recorded subdivision covenants. I know that may be confusing to some people who have been told that we were suing the association or we were suing to dissolve the association. Nope. This lawsuit has always been about protecting this POA, which has been operating legally since 1967, and maintaining its ability to continue operating legally so that those of us who depend upon this road can enjoy our properties and our investments. In comparison, the unauthorized incorporation had no property owner vote for authorization, no board approval. It had very suspicious timing since it was filed right after the board was supposed to have had elections and before the new elections that were scheduled occurred. At one point, Kay, my mom, had asked Kelly Harrell, why did they do it in secret? And Kelly Harrell stated, I'd have to find the recording, which I can if anybody wants to doubt this. She said, no, we had to do it before the new board came in. So that's not a sign of proper governance and transparency. It was also hidden from owners, not just hidden from owners, it was hidden from the new board members. Jerry Sullivan and Charlene O'Brien were elected that year to the board, and they were not informed about the corporate formation. And Charlene was acting as treasurer at the time. The difference between an unincorporated nonprofit and an incorporated nonprofit would impact her duties as treasurer significantly, yet she wasn't notified. So this is what the plaintiffs, which is the people that filed the lawsuit, me and Mike, asked for. We wanted a declaration from the judge, official court ruling that CBA POA is the valid legal association and the secret incorporation was unauthorized, an injunction, which is just basically a court order preventing unauthorized actions and protecting the POA from future confusion, and protection of rights. We wanted to ensure that major changes require property owner approval and that the community's voice would remain protected. It was not about shutting down the POA, dissolving the association, taking money from anyone, personal attacks, defamation, punishing volunteers, none of that. It was about rule of law governance and restoring clarity. Basically, I come to this as a business problem. I live on the lake. I am dependent upon the road that I drive into to go to and from town and to work. And our POA maintains that road. Our POA needs to maintain legal consistency and clarity and be able to do its job. That's what this was about. Okay, so now we get to the point where Mike and I decided to non-suit this case. We chose to non-suit, which means withdraw for the time being the lawsuit because the case could not be heard fairly in this venue at this time. This was largely due to what we feel was inappropriate behavior by the defense and defense's proxies and the unfamiliarity of the assigned judge with the prevailing law of the case. This decision was not made lightly, and it does not mean that the case was weak. There was no judgment against our case or the merits of the case. It was withdrawn. So the judge was unfamiliar with controlling law. The majority of this lawsuit is based upon Business Organizations Code, to which the judge had stated that he had been on the bench for 50 plus years, and he said, I don't think I've ever read that. And then when I referenced Business Organizations Code to explain why just because there was a document that used the word corporation, that did not mean that the association previously was a corporation, he said, I don't care about the Business Organizations Code. That's a pretty telling statement because it's black letter law, which means it's undisputed law. It's just accepted as is, and for a court to say that he doesn't even care about that was pretty remarkable. The other factor here was that the judge received at his home a stack of communications that I still haven't been given access to, that he states he was saying some statements like, well, based upon what I read, there's been intimidation and harassment and stalking and illegal actions and self-dealing, and he read off a bunch of stuff. So we can imagine what nonsense got sent to this judge's house, and him not being a computer person and not being able to go and kind of verify some of this stuff or whatever. He was heavily influenced, and he said, I can't unread what I read. Now, this is really problematic because a judge is supposed to be impartial. The trial had not started yet. We were still talking about jurisdiction, and he was making statements about the actual merits of the case, things that are properly weighed in trial when actual evidence is submitted and not informal letters and who knows what other nonsense sent to his home address. So the judge became openly hostile to me, to Mike, to the association, based upon his interpretation of these ex parte communications, and admitted that whenever he told us that we needed to pay for the defense to write up an order, that it was because of what he felt was our conduct based upon these ex parte communications. The third factor was that procedural issues had been ignored from the beginning. The defense did not serve their answer. They did not file their answer in a timely fashion. There are a number of just procedural things that their defense lawyer did not do or then lied about in court. And I had evidence to show that he did not do his job and that he lied to the court, and the judge didn't want to look at it. He says, I'm not going to listen to that. I'm not going to read that. That's what was missing was the very first move of the defense that all time windows get calculated off, and that's when the defense serves their answer. They filed late, which could have led to immediate dismissal of their defense, but it didn't, because on the day that we had the hearing, because the answer was not served on time, their lawyer did not show, which would have been another reason to have the defense thrown out and the case decided in our favor. But unfortunately, it was in front of a judge that felt that he needed to recuse himself, Judge Travis Kitchens. So then by the time we came back, the lawyer had stated that, well, no, I didn't serve them by mail. I served them through the e-file system. And the judge took his word on that, along with the deputy district clerk, who apparently looked at her computer screen wrong. I came back with evidence that that did not occur. Evidence from the defense's law firm that showed, it was a screenshot of their filing. It showed it was not. There's a spot where you click that it gets served, and it was not. It shows that it was not served to us. But the judge refused to look at any of that. And I understood, okay, he's not going to throw the case out anymore. Like, it's not the same as like the day that we all showed up and the defense lawyer didn't, and nobody from defense showed up. That would have been an obvious, just go ahead and dismiss the case and award the plaintiffs. But we're further into the case now, and I understand that the judge wasn't going to throw out the case based upon a procedural error, but it needed to be fixed and the time windows recalculated. But the judge didn't rule on my motion. He just said, I'm not going to listen to that, which is another procedural error, because he still needs to, when the case is still active and a motion is filed, he needs to say approved or denied. And this was also a pattern. There were multiple motions that were never ruled upon. The only motion that was ever ruled upon was the very first one, where I asked for default judgment because the answer hadn't been served. Every other motion was never officially ruled on, and no other orders were signed. So this is what a non-suit without prejudice means, which is what we filed. The plaintiffs voluntarily withdraw their lawsuit. There is no judgment. The judge doesn't say, awarded, denied, this, that, whatever. There's no judgment on the lawsuit itself, and the plaintiffs retain their right to refile. So this decision protects the community long-term by preserving the right to refile if the defendants or their proxies attempt to revive the unauthorized corporation or continue to interfere with the legitimate POA operations. The publicly available documents and affidavits that were generated by this lawsuit have already been shared to the Secretary of State, Attorney General, and Texas Department of Insurance, who already had open cases related to this situation. So for us, the non-suit made sense because a number of our goals for the lawsuit had already been achieved. We got documentation, including a signed affidavit from Kelly Rahm, that there was no board authorization, no property owner vote existed. We have affidavits from at least one director that was listed on the corporate formation document that he did not consent to that. He didn't consent to being a director of a brand new corporation filed in our name. And by doing the non-suit, it means that no ruling on the merits ever occurred. There was no trial, there's no finding that any of the claims were wrong, and the case never moved past the jurisdictional issues that the defense kept arguing. So basically, they were arguing that the whole lawsuit was moot, meaning it was pointless because the corporation had already been closed. And our argument on that was it was never legally formed. It can't be legally closed. We wanted the Secretary of State to just void it, make it where it never legally existed. And then the other thing was they said that the court didn't have the right to be able to do anything. And that's not true. The Texas Business Organizations Code has a whole chapter on what the district court can and cannot do in relation to business entities, including a judicial, basically declaration that states which is the operating association, a judicial declaration about whether an entity legally exists or not, These were things that definitely fell within the jurisdiction of the court, but our case never went past the plea to jurisdiction that the defense had filed. So I got to point out that the days when Kelly and Kelly looked happiest in this lawsuit were the days that the judge made threats against the POA or said things like, well, I'll dissolve that and leave you without a POA. How would you like that? And so I want to point out why the POA matters and why this non-suit helped protect the POA from an overreaching and biased judge. The POA, its main job, and Joe Chambers says this just about every meeting, and I have to shake my head and say yes. The main purpose of our POA is to take care of this road. The county is not going to step in and take over this road. It is crucial especially for those of us at the end of the road, to have good access in and out. This affects our 911 access, like we saw back in 2024 when we had difficulty with the rains and getting fire trucks and ambulances in here and stuff. The county will not take over our road. It doesn't have the funds to do that. It's not that they're trying to be mean or whatever, but do you know how many POAs would love to give up the cost and responsibility of taking care of their road? And so if the POA went away, nobody can force anybody else to take care of that road. We all just become like Port Adventure. And I know that a lady from Port Adventure had been brought over to explain why what they did over there is kind of like what we should be doing, but you really need to go drive through Port Adventure at some point to see what a private road looks like when the county and the POA have given up on it. There's sections where rebar is sticking through. You could lose a tire, you could puncture a radiator, who knows? So the POA matters. Its purpose is not to tell people how to live their lives or whatever. The main overreaching goal is take care of that road. And then some like basic common values to share and to enforce. And those things are what the bylaw committee will be trying to address. And you can have some input with them and let them know what you think is good and what's bad and everything else. But the nice thing is nothing gets taken care of, nothing gets changed in our bylaws without a property owner vote, because that's how it's supposed to be. I know that the bylaws were changed unilaterally 3 different times in the last 2 years, but I think that's been clarified and probably argued into the ground, but bylaws aren't changed without a property owner vote. So there's 2 legitimate paths forward. We are now, as we have always been, an unincorporated nonprofit association. That means that our property owner dues are collected and used for the mutual benefit of everybody here in the association. Texas already recognizes that property owner dues are tax exempt. You don't have to go and do an IRS tax exemption status or any of this other stuff. In fact, I know at the last meeting, Kelly Harrell had mentioned that, we're not listed as tax exempt with the IRS. I would love for her to go back to that webpage where she searched in the database to see if Camp Branch Acres was listed. Please show me any POA in Trinity County, Walker County, Polk County that is federally tax exempt. Show me in the database. Because I've looked and nope, none of the POAs in our area are federally tax exempt, which would require a 501c3 or a 501c4 status. And the closest was at one point, Westwood Shores had a garden club that was federally tax exempt, but not the POA. So interesting. What is tax exempt is things like Knights of Columbus, animal shelter, food bank. What you see there is basically funds are raised for other people's benefit, not for ours. So 2 legitimate paths forward. we remain unincorporated or we incorporate, but that would require the property owners to, be notified that this is coming up for a vote, be given actual, real, accurate information about what the two options are, and then take a vote. Even though the ballot was heavily skewed this last time, in May of 2025, the property owners still voted overwhelmingly that they did not want to be incorporated. So I think the path forward is respect and carry out that decision responsibly. So I think Camp Branch Acres is worth protecting. I love living here. I've had decades of history with this lake. I know other people up and down my road, they've had a lifetime of history with this lake and Little Lake and the association and the community. By respecting the law, respecting each other, and making decisions together, we can preserve our roads, our community, and our shared investment. So let's work on strengthening and bulletproofing these categories here. We need to have clear authority. Our CCRs are old, but they are still accurate. There's a couple things that could be modernized, but as long as we're not trying to enforce those sections, we're okay. For example, there's a spot that says no immoral activity. That would be really hard to try to let's hope nobody decides to be the morality police around here, because that would be ridiculous. So there are some things that need to be cleared up and modernized, but overall we have clear authority. It would be nice to see some delegation of authority to particular officer duties and roles. That needs to be voted on and put into the records as like a policy of board delegation of authority to officer positions. We also need clear records. When the 2025 election happened and the new officers came in, a bunch of records were left under a tree by the previous officer, and digital access and accounts were not turned over. There are still some accounts that the association doesn't have access to. These things need to be proceduralized. Let's make a procedure on how authority gets transferred from one officer to the other, and have it either witnessed or signed off by the old officer and the new officer before it's considered complete. Also, Kelly Rom had stated at the last meeting that she had shredded some documents, but those were just the real old documents. There is no authority to do that without some type of policy for destruction of records. Most nonprofit boards will have a log of documents that will be destroyed, and then that is sent out to the members of the nonprofit, who then have a period of time that they can dissent against something being destroyed, and after a certain period of time they are shredded, and there is a note in the log of what was destroyed and on what date and by who and by what method. We also need clear votes just to ensure all major decisions involve property owner approval. Votes should not be worded to try to sway people to vote one way or the other. It should be clear and neutral language, and we should be working on making sure everybody who has a valid vote gets their vote heard and counted. We need clear communication, making good use of the website, and being able to put more and more information on there. Right now, for the dues, there is a page that shows how dues can be paid electronically, and then there is a tutorial video. I was asked to go through and pay my dues that way and take a video of the process, so I did do that. Gave that over to the secretary, who uploaded it to the POA's Google services, and then posted that video on the website so that it can show, here's how to pay your dues, and here's a video showing you the process. We need mutual respect, and that's just fundamental. But I know there's been a lot of people describe the Facebook as hateful. No, actually not. That would be a violation of the rules, and people have been removed for being hateful or for posting just purposefully incorrect information in order to start drama or to divide the community. Seems that the people that complain the most about the Facebook group aren't in our Facebook group. Our Facebook group has a lot of property owners talking about who does trash removal and how to protect your pipes with the freeze coming up, and there's a fish fry at the fire department, etc., etc. It has been used to point out information that the board at that time did not want out, did not want communicated. So it has been used before to show when something's being done wrong. However, I've always emailed the board first and waited for a response, and when no response, then I would take it to Facebook. So mutual respect, treat each other with dignity and professionalism, and then property owner control. We just need to remember that the POA is run by the property owners. The property owners vote for the board, and the board votes for actions that they're allowed to make actions of, but the overall authority actually is with the property owners. And the Texas Property Code recognizes that because Chapter 209 is the Texas Residential Property Owners Protection Act. The focus is on protecting the property owners. So we wanted to move forward, and we reached out to a licensed lawyer here in Texas that deals a lot with POA, property law, and what he calls legacy associations. So he's very familiar with associations that have, the founding in the 60s, the 70s, the 80s. We paid for him to spend several hours reviewing all of our documents, and that's the history, the governing documents, the meeting minutes, and he's very familiar already with Texas business law, but he reviewed the particular chapters for unincorporated nonprofit and formation, things like that, nonprofit purposes, etc. So he did provide a formal legal opinion that's signed by him, which actually provides liability protection for the board and the association. Due diligence and governance, you can always point that you had a signed legal opinion from a licensed Texas attorney in good standing, and that will protect you from liability. So he also provided an executive summary. So he took that 3 pages of explanation and brought it down to basically a Q&A sheet. The common questions that have come up in the last couple meetings and his answer based upon legal fact. And then, like I said, this does reduce liability by providing a legal basis for the actions that the board takes and the positions that they take. And that helps reduce the liability for what is, at the end of the day, a volunteer board. We need to have volunteers on the board that want to do the work of the association and are protected from baseless lawsuits. Won't protect you against, won't protect you against wrongful actions, and won't protect you against unauthorized actions, but the actions taken by the association and the actions taken by the board as a whole that are based upon a legal opinion are indemnified against liability in Texas law. Oh, and I've probably said just enough for today, so thank you. Thank you for listening. I can be reached by email at jenharristx@gmail.com. I have a YouTube channel. That's where this video is posted, and you can go to the association's website at www.cbapoa.org to look for any information from the association itself. And then I'm an administrator of the Camp Branch Acres Residents Facebook page, along with Tim O'Brien. There's the link, which is, nobody's going to type that in. So just, if you're on Facebook, you can search for Camp Branch Acres Residents and join if you would like to. We do keep it down to members of the community and those associated with the community. So family members, neighbors, officials in our community, things like that. If you have any questions, just reach out to me, but have a great Friday. Bye-bye.